The future of fair voting rights hangs in the balance as the Supreme Court prepares to make a decision that could fundamentally alter the landscape of American democracy. But here's where it gets controversial. The court is weighing whether to dismantle a crucial part of the Voting Rights Act, a law that has been a cornerstone of racial equality in voting since 1965. This isn't just about legal technicalities. It's about whether states can consider race when drawing electoral districts to ensure minority representation. And this is the part most people miss. The outcome could drastically reduce the number of minority lawmakers in Congress and state legislatures, reshaping political power for years to come. On Wednesday, the conservative majority Supreme Court will hear oral arguments in a case from Louisiana that challenges the very essence of Section 2 of the Voting Rights Act. This provision, enacted during a time of profound racial discrimination, requires states to ensure that minority voters have an equal opportunity to elect representatives of their choice. The case centers on Louisiana's congressional map, which was redrawn last year to include a second majority black district after a lawsuit alleged the original map violated the act. In a state where 1/3 of the population is black, the initial map had only one such district, a glaring disparity. What makes this case particularly contentious is the court's decision to expand its scope. Earlier this year, the justices heard the case on narrower grounds, but in a rare move, they asked the parties to re-argue it in June, focusing on a broader constitutional question. Does drawing districts to ensure majority black representation violate the 14th and 15th Amendments? These amendments, enacted after the Civil War, were designed to guarantee equal rights for formerly enslaved individuals, including the right to vote. Conservatives argue that these amendments prohibit any consideration of race, a stance the court has increasingly embraced, most notably in its 2023 ruling ending race-based college admissions. Louisiana, which initially defended its redrawn map, has now switched sides, joining a group of self-identified non-African American voters who argue the map is unconstitutional. The Trump administration supports this position. Meanwhile, civil rights groups are fiercely defending the map, arguing it's necessary to comply with the Voting Rights Act. The Voting Rights Act has long been a target for conservative legal challenges. The Supreme Court weakened it in 2013 and 2021, but in 2022, it surprisingly upheld the requirement to consider race in redistricting in an Alabama case. That ruling was a narrow 5-4 decision, with Chief Justice John Roberts and Justice Brett Kavanaugh joining the liberal justices. However, Kavanaugh expressed doubts about the long-term viability of Section 2, hinting at the ongoing tension within the court. If the court rules broadly in Louisiana's favor, it could significantly reduce the need for states to create districts with large minority populations, likely leading to fewer minority lawmakers. A quick decision could allow states like Louisiana to redraw districts before the 2026 midterm elections, potentially benefiting Republicans, as black voters tend to favor Democratic candidates. But here's the bigger question. Is a colorblind approach to redistricting truly fair in a country with a history of racial discrimination? Or does it perpetuate systemic inequalities by ignoring the very real barriers minority voters still face? This case isn't just about legal interpretation. It's about the soul of American democracy. What do you think? Should race be considered in redistricting? Or is it time to move beyond it entirely? Let's hear your thoughts in the comments.